Hi, my name is Braden Blumenstiel. I'm a partner at the law firm of DuPont and Blumenstiel in Dublin, Ohio, and I've been asked to explain kind of the process that goes along with a will contest action. Basically, with a will contest, normally they only arise after, unfortunately, someone has died. Normally, what happens is someone passes away. That's called the decedent. And when the decedent's will is reviewed, someone says, wait a second, this is not an accurate reflection of what my mom or dad or sister would have wanted, and they feel like something sketchy kind of happened. And that's when they'll normally contact an attorney who does work with these types of issues. The standard, if you're challenging a will, what you have to do as the plaintiff is you have to demonstrate that that will is not an accurate reflection of the decedent's true desires and wishes. There's two main ways that those cases can be proven. One is this thing called lack of testamentary capacity. And that basically is just saying they had such problems cognitively that under Ohio law, they didn't have the cognitive ability to change their estate plan. That's very rarely occurs because it's a really low hurdle on whether or not someone can change an estate plan and whether they have the cognitive wherewithal to do that. So the vast majority of these cases turn on this thing called undue influence. And simply put, undue influence is an allegation that someone came in and made the decedent change his or her estate plans in a way that they would not have wanted to absent this undue influence. And so that's the main claim in most of these cases. Decedent was unduly influenced into changing his or her estate plan by someone else and was forced to kind of do it even though they didn't want to. How do you prove that? And that's kind of the trick of these things. It's easy to say that what you believe in terms of, well, mom wouldn't have wanted it this way. But it's a lot harder to actually get the evidence to prove these claims. In general, what you need to do is you need to gather things to show how the decedent was doing cognitively and physically at the pertinent time, i.e. around the time the will that you want to contest was made. You want to see what kind of activity the person who you believe unduly influenced the decedent. I just say that's the villain. That's the way I just phrase it. It's the villain. You need to compare and see how much involvement did the villain have with the decedent's estate plan. Was the decedent susceptible to undue influence? And that's kind of one of the things you have to prove, that they were susceptible to undue influence, which basically means there's something about them physically or cognitively that they kind of were in a weakened position that would allow someone like the villain to come in and kind of unduly influence them into doing something they otherwise would not have wanted to do. So you have to show susceptibility. Well, how do you do that? You do that through getting the medical records and reviewing them. Medical records are going to tell you a lot about how the decedent was doing when that will was drafted. So after you do the review of the medical records, you typically will get the file of the estate attorney who drafted the will that you want to contest. When you start looking through the estate plan or the file of the estate attorney, what are you looking for? You're looking for evidence that the villain was involved in that process. And it could be telephone calls. It could be that the villain was paying the estate attorney. It could be that the villain was in the meetings in which the estate attorney was speaking with the decedent before executing this will that you want to contest. So the more involvement you see by the villain, the more likely you are to be able to prove your case. Another thing would be people. You get evidence from people who've been around the decedent during that pertinent time, because you have to show, again, that the villain made the decedent do something that he or she did not otherwise want to do. And so there may be people that have neighbors or friends of the decedent who says, yeah, this guy, villain, was around a lot, was kind of taking control, was doing a bunch of stuff that we felt was improper, just kind of taking control of the decedent. Other things you can look for is the villain's involvement with such things as the financial affairs of the decedent. Was that person actively involved in paying bills? Was that person taking advantage of the decedent by taking money from their accounts for his or her own purposes? The more involvement you have with the villain in terms of activities and kind of controlling the decedent, the more likely you are able to show that they unduly influence the decedent. Now, the ultimate objective, the ultimate thing that you have to prove is that the villain unduly influenced the decedent to such a degree that basically they took the free will away from the decedent, and they kind of instigated and were leading the charge to change the estate plan. And if you can convince a jury that that's the case, the jury will come back and declare the will null and void. What happens then? Okay, well, if you get a will declared null and void, what takes its place? Well, if there was a will that preceded the will you were contesting, that one becomes activated. And then you'll go by the terms of that will to determine how assets of the decedent are distributed upon death. There's more to that stuff than I've laid out here, but if you have any questions, feel free to give us a call. We can try to answer them for you.